I'm good in the back? All right. All right, seeing that it's Tuesday, October 7th, 2025 at 6 p.m., I'll call the Town of Webster Zoning Board of Appeals meeting to order. Please be advised that this meeting is being recorded. First item on our agenda is August 5th and September 2nd's meeting minutes.
Yes, both sets of meeting minutes were transcribed directly from the video on YouTube. If you feel like you need another month to look them over, not going to hurt my feelings, but they're about as complete as I can get them.
Okay. I'm okay with them. You're fine? All right. All right, is there a motion to accept the meeting minutes from August 5th and September 2nd?
I'll make that motion.
Any discussion? Hearing none, Ms. Morgan, can you pull the board?
Yes, Mr. McMahaffey?
Yes.
Mr. Knoyer?
Yes.
Mr. Daggett?
Yes.
Mr. Chahowski?
Yes.
And Mr. Piaf.
Yes.
I forgot to turn on my mic.
Yeah.
Yes.
Yes.
All right.
Wait, you turn those on?
Yes, yours is
Yes.
red.
Yeah.
I know.
Next item is our draft decision from the second remand of Cronin v. Finton.
Yes, I know the chairman did the heavy lifting on this. We're going to get town council on here first. Hold on. Brendan, how do I proceed with this, Brendan? That's her number there, yeah.
Okay. Hi, Robin.
Hi, Jason.
This is the Webster ZBA. And we are
Excellent.
at.
Thanks for accommodating me.
Nope. So we are at the point of discussing the draft decision of the board for Cronin versus Finton, and our third decision. So we'll start with anything you want to say first, or do you want to take the board through the analysis? We have screens in front of us.
However you would prefer to do it. I believe Ann added the exhibit, so I definitely want to make sure that just the order they got added in match how they're referred to in the decision. So that's something to just double check if you haven't already. But, it might be, you tell me it might be easier with you in the room if you want to walk through it. If not, I can, and then answer any questions. You tell me.
You know what, I think if you go through the background information, I can take over the garage dimensions and volume calculations. And I can take the board through our logic in the discussion, which is the written decision of the four issues. So
Sure. So yeah, I think as everyone knows, this is the second remand to the board in this case involving 16 Robinson Road and a reconstructed garage. The decision obviously contains the information involving the case and the parties and the property. The background section just lays out the most recent judgment and decision from Judge Vey in the Land Court, which came out in November of 2024. It has information that discusses the remand and the scope of the remand, as well as the board's request for clarification on that, and some background about the Vintons and the Cronins positions on what the board should be doing. And that's pretty much the bulk of the background section.
okay.
There's a section on exhibits and submittals. I haven't seen the full list of that's been added in, but I think that's probably pretty self-explanatory. Again, just want to make sure that matches with the internal exhibit references in the decision. And then there's a finding section where the board has, explained what the board did. And I think, Jason, I don't know if you want to pick up here and talk about the dimensional part, or if you want me to kind of go to the end of it and come back. How do you want to do it?
Yeah, I think we'll go linearly, so I'll talk about the dimensions. So if you
Okay.
remember from our meetings, I think this goes back all the way to February of this past year is when we first reopened the public hearing, or reopened the public hearing on this issue, on this case. And we had to find calculations of the old garage, what was proposed, and what was as built. What was difficult and why we had so many hearings with the parties was because in our first, or our second decision before this, we only dealt with what was in the setback. So we were missing the long side of the L that would, if we were looking at L, is extending vertically. So if you look on page, I don't have the page here, but F14, you can, so we were, the front section, that part was within, that portion of that front section was in the setback. So we only found a couple of dimensions as it related to that front section. The whole rear section was absent. The heights were absent in a lot of cases. So there's a finding in here for every single dimension with cites either to our previous decision from 2021, the court's first remand, and some of those are the same dimension, or to what was found or provided for us in this past hearing of this summer, in spring. So it starts with linear dimensions. For example, we have, or shape, first of all, you gotta find the shapes. Don't want to argue about that. The ground story. Then you have a series of linear dimensions. Then you have a finding as to what the roof shape is. It's overly thorough just to limit areas of possible issues that we argued later that could bring this portion back for us to find and argue with the parties about, and try to pull that dimension out of them. So once you're done with your linear dimensions, now you got to find volumes. So volume's always in cubic feet. So you need 3 linear foot measurements to get a cubic foot dimension. And so you multiply them together. That's how you get your volume. So there's volumes for the ground story, and the roof. They're separated that way because they're separate geometric shapes. There's established formulas for the volume of a rectangle and the volumes of a pyramid roof for the old garage. And then you add your roof and your ground story together and you get your total volume, simple addition. Moving on to the proposed garage, again, we have the L shape. I don't think anybody would dispute that that's the shape of the garage, at least roughly. So it's going to be broken into 2 rectangles. The rectangles can be separated, and you do the front, or you do ground story and the roof. The roof of the roof shape. I know there's a roof shape finding in here.
Yeah, something.
Yeah, the roof shape of the front section.
F20.
Yeah, okay. Yep. Yeah, F18, so it's a triangular in shape, and again, it's cited to the exhibits. That goes back, I cited to the Exhibit 10 of their 2017 variance applications. Some of the items were in there because we're looking at the proposed shape. The initial application in this dispute goes to a failed variance application that the Vintons filed. So thankfully, we still had that on file. So, and this was really tough to get what they proposed because there wasn't a lot out there. You really had to do a lot of digging. So we got the shape, we had the height. So we took the front, we had the front section, take the roof, and you take the ground story, and now you have your total. The rear section was pretty complicated because their variance was denied. So that created a area that was unbuildable in the northeast corner of the property. So I broke it into 4 geometric shapes. You got the southern section ground story, northern section ground story, and each roof. Luckily, the southern section roof was just a continuation of the front section because they kept the same peak throughout. Where it got tricky was figuring out the proposed height of that northern section roof because they had to have proposed a garage with an L shape because they couldn't have built in the area where they were denied the variance. So you can't say that the whole garage was of a rectangular shape. So this brought back some high school geometry. I think this was sophomore year. Thinking about angles and how to find angles of a right triangle. So we knew the height of the ground story roof. We knew its width, 15 feet, because the width of the front section roof was 30. So divide that in half, you get 15. So I was able to solve for that unknown angle, and that turned out to be 36.25. And that was able to be transposed onto the angle of the southern section was able to be transposed onto the angle, onto the northern section because they maintain the same peak. So the angle of the northern section roof has to be the same as the southern section. They couldn't vary because they kept the same slope. They had the same slope because they were continuations of the front section roof. It was just a section that was notched out where you had a larger wall in your northern section. So now that I had an angle and a side, I was able to calculate the height of the northern section roof, and that was found to be 5.13. Throw on the 1-foot eave, which was pretty easy because I think they admitted that during the hearing that they proposed a 1-foot eave. And do your triangular and rectangular volume formulations, add the ground story and the roof volume together, and you have your total volume for your rear and front sections. And you add those together and you have your total volume. Same thing for what was as-built. Again, these were all taken from exhibits or testimony. There really wasn't any disputes between the parties. I don't believe the Cronins, through their attorney Lane, offered any contention at any of the dimensions. Most of these were taken through the hearings was taken from the Vinton submissions. Or I think all of them were, unless they were found by the board in its second decision or by the court. So now we have our volumes. If you turn to section 4, at page 22, where we're looking at the percent increase. So we're thinking about 25% because that's what the 2017 version of this bylaw limited a expansion of a pre-existing non-conforming structure to. So the increase of the as-built garage compared to that, which was the one that we believe exists, to the old garage is 620%. So that far exceeds the 25% threshold. Then the percent increase of the as-built garage compared to the proposed garage, and the reason why this had to be made is because of the timeliness of the Cronin's appeal, was found to be 33.8%, 831. So again, that exceeds the 25%. So both of them exceed that 25% allowable expansion. So now we're able to get into our analysis of the first of the bylaw. Actually, is there any questions before? No. I know that there's a lot there. I can promise there's logic behind it. None of these numbers were pulled out of thin air. And if there was any disputed numbers, they would have been stated, but luckily for me, there weren't. So otherwise, we'd be voting on them, or the ones that were in dispute. So we have our 2017 bylaw, which has the language, which has the italicized sentence that's at issue here, which is the 25% allowed expansion. And the first issue was to figure out what that bylaw applied to. So Attorney Lane for the Cronins contends that it applies to the entire non-conforming structure. The Vintons probably would contend that it applies to the only portion of the structure that's within the setback that's non-conforming. In thinking about how we've applied it in my past on this board, how we've analyzed applications, special permit applications that I've been involved with several building commissioners, we've only looked at parts of a non-conforming structure that were within the setback or created the non-conformity. And I thought it was unreasonable if we took Attorney Lane's assertion that the entire building is non-conforming if it exists within the setback to say that, okay, if I have a building that's within an inch, say it violates setback by 1 inch, under his logic, an argument, then the entire building becomes non-conforming. And I find that to be absurd and a little bit extreme. So I reasoned that, and I hopefully the board reasons that that the 2017 25% expansion only applies to the portion within the setback, the non-conforming section, and that's also how we initially. That's how we initially analyzed this case with on our 2021 remand decision. Again, other members can make their own findings, but that is what I found. Any questions on that? No. Conversely, on the lot size. So the lot size gets a little tricky because there's actually, before I continue, Attorney Stein, is there anything you want to add to Section A that I might have missed?
Nope, definitely deferring to you on the math. So that's great.
Or I mean, on the bylaw, the 2017 bylaw.
Oh, no, I think the way that you've explained it is consistent with my understanding of the board's recent deliberations and past action, essentially that you can make a 25% increase to a nonconformity. And otherwise we need a special permit.
Okay. So looking at Section B, which deals with the lot size. So the lot size is a little bit tricky because there is an issue of timeliness. Now, that's not an issue that we can resolve at the ZBA level. That's more of a question of civil procedure and law for that will be decided upon probably by an appellate court after the land court makes its ruling. But what the issue we had to decide was whether or not, assuming that it's been timely raised, does the non-conforming lot size, because it's less of the Vinton's lot, because it's less than 12,000 square feet, does that create a non-conformity that causes the entire garage to be non-conforming? So I use my logic from Part A to say, well, the percent expansion applies to any area where there's a non-conformity. So if their entire lot's considered non-conforming, then therefore now the entire structure is non-conforming. We're not just looking within the 25% because that entire lot is non-conforming. And you would otherwise need a special permit to make any alteration to any building because of that. And there I found that the 25% by right expansion applied to the entire increase in size. So didn't find it in Part A, but found it in Part B using the same logic. So we're consistent in our analysis, which I think is important. But so we're now thinking about the 620 and 33% expansion. We're now saying that, yes, a special permit might have been required. Anything to add there, Attorney Stein?
No, nothing.
Nothing. Part C. So if we thought about this was old versus new, and whether or not we were going to analyze the as-built versus the old, or the proposed versus the as-built, because both of them exceed 25%, the issue is really moot. In either case, you get to the same conclusion, where it is a special permit. Then we started getting into, and this was part of our last hearing, I believe, we started talking about as-right expansions of single and two-family homes. In their case, it's a single-family home. With lawyers would say Bellata analysis under Bellata, which was cited in the first sentence. Here what do we do? All that was said was here is that the parties agreed that it was detached, and we didn't take a position, but it's important to note that it's detached because the statute, as it states, seems to imply that detached garages aren't covered by that statute. So that might be an issue that comes back on remand. And may or may not, depending on what the parties do on appeal. So we'll see, but that would be a case, a lot of those issues would be a case of first impression for an appellate court. And conclusion with zoning relief. To sum it up, they're required to have a special permit. So anything that I missed, Attorney Stein?
No, I think you walked through what's in the decision. I can certainly answer specific questions if anyone has, but nothing to add.
Any questions? Any questions, Ann?
No, but I will go and complete the formatting based on previous decisions that you've had, so just to make sure there's consistency. The numbering is correct for all the
Okay.
findings and everything, but I'm just going to zhuzh it up a little bit.
Okay. All right. So would anybody want to make any corrections or alterations to this decision? Hopefully not to the math part, because we have a really long night if that was the case. All right. So the motion that you typed here, Attorney Stein, is the motion that should be made?
Oh, I don't think I provided a motion, but I think you could.
You said a motion
You
was
mean
made. A
Oh,
motion
in the
to,
decision, sorry, I apologize, yeah.
Yeah.
Yes, you could have a motion to approve this as your decision, but now also just to authorize Ann to, format it consistent with your prior decisions and to authorize you to sign it.
yep. I think we'll take those individually.
however you want to
Yeah,
do
well, I'm
it.
going to take those
Sure.
individually.
Sure.
So is there a motion to approve and adopt the decision as the board's decision after the second remand hearing?
I'll make that motion.
I'll second it.
Any discussion? Hearing none, Ms. Morgan, can you pull the board?
Mr. Canoyer?
Yes.
Mr. Daggett?
Yes.
Mr. Chahowski?
Yes.
And Mr. Pilar?
Yes. All right, is there a motion to allow Ms. Morgan to format the decision to match, what did we say, Attorney Stein? I didn't,
Just your usual format, but not substantive changes. Yeah.
to match our usual format.
I'll make that motion.
I'll second it.
Any discussion? Hearing none, Ms. Morgan, can you pull the board?
Mr. Canoyer?
Yes.
Mr. Daggett?
Yes.
Mr. Chahowski?
Yes.
And Mr. Pilar?
Yes, and last but not least, is there a motion to allow Ms. Morgan to sign the decision on the board's behalf?
I'll make that motion.
I'll second it.
Any discussion? Hearing none, Ms. Morgan, can you pull the board?
Mr. Canoyer?
Yes.
Mr. Daggett?
Yes.
Mr. Chahowski?
Yes.
And Mr. Pilar?
Yes. All right. We're done with 16 Robinson Street.
All right. Thank you
All
all.
right, thank you.
Have a good night. Thank you.
Bye. Next item is the draft decision, special permit application, resubmission of 13 South Point Road.
Okay, this is your standard condition format. Findings F1 through F13. Document any kind of documents that were received or testimony heard at the public hearing. Specific to this particular application is F3. This application is a resubmission. The previous special permit was denied primarily on the lack of parking, and that was all discussed at the public hearing. Then F4 gets into the conversation that was had prior to taking testimony from the applicant or people in the room about, what constitutes a material or a change enough to make this a new application as opposed to a repetitive petition. So that was the issue that was raised, that the board was going to be looking to discuss with the applicant and anybody in the audience who wanted to address that issue. This is all taken right from your meeting minutes. F5 is the conversation that you had with the applicant, Melissa Karen, and this goes into the changes that were being proposed since the last submission application. So it's fairly long. She does note at the end of the meeting in her summary that she did, through the 3D model that she had submitted earlier, she had eliminated certain area. She'd taken off the front porch to created extra turf area with an extra parking space. So It's her contention that she did change the footprint, eliminated the entire front deck in order to accommodate the additional parking space. So that was her final explanation. Then you get into the comments submitted during the meeting, F6 and F7. F6 is Adam West. I didn't feel the need to repeat what is already in the submitted comments, which is in Exhibit 12. So that just notes that there was a submission for people to refer to under Exhibit 12. Under Exhibit 13, Renee Dumont, 12 South Point Road, also submitted comments to the board, which were entered into the record. Exhibit 13, she sat down and reviewed those comments with you directly from her submission, so I didn't feel the need to repeat that. Then you heard from Ed Hickey, 12 South Point Road, and a lot of his concerns were about public safety and the fact that the road is very narrow and it's a peninsula. And I specifically called these out in these findings because you did ask each person, or most of the people, you asked them if the board asked if Mr. Hickey thought that landscaping, the addition of a retaining wall and increased parking spaces constitute a material change to what was submitted previously, and he responded, I think it's dangerous the way it is laid out. He reviewed his reasons, including the location of the fire hydrant and the telephone pole. Next is 24 South Point Road, John LaFave. He stated that the landscaping and the addition of parking spaces does not, in his point of view, materially change anything from the first meeting. He was there to stress the safety part. And then Linda Littleton, also 24 South Point Road, reviewed a number of issues and concerns, safety, believes the lot is undersized and the proposed house does not meet the setbacks. That's her opinion. She also was concerned about the vegetation being removed from the lot, and it didn't appear that required permits were being followed. Again, her opinion. When asked what she would consider a material change, her response was, I believe it would be structural, that they were going to be moving the building line or the building spot itself. The landscaping, I mean, if you really have to go up and really take a look at it, I don't know how they're going to get 4 parking spaces in there and landscaping on this. Then Pam Sheeran was the last person to speak to the board. She's at 6 South Point Road. She raised concerns about the environment and habitat and vegetation and the impacts to the wildlife, but when she was asked about what constitutes a material change, her response was, I don't understand how changing the size of the home, you can suddenly make it 4 parking spots because nothing has really changed. I think material change means the physical material. Either the size of the house would have to change or something really significant. So to add a parking space isn't a material change. You're not downsizing the size of the home. F12 outlines that you received no comments from several boards, fire, police, Southern Worcester County Communications, conservation agent, the assessor, the town administrator, and the water and sewer department had no comments on the application. And then you did receive from the highway department 1 comment that the street is not wide. On-street parking would be a problem on that street. So when you get into the next section, which is specific findings, the very first finding you have to make, and this is a supermajority vote. Kathleen is eligible to vote, so there are 5 of you here. Has to pass by 4. Is that you have to with regard to whether the new submission is considered materially different from the previous special permit application denied in 2025, the board finds. And then you're going to take a vote as to whether or not this is materially different. If you decide that it is not materially different, then you go right to the decision. If you decide that it is materially different, then you're going to get into the criteria for granting special permits.
All right. Is there a motion to adopt findings F1 through F13 as presented?
I'll make that motion.
I'll second it.
Motion, a second. Any discussion? Hearing none. Ms. Moore, could you pull the board?
Yes, McStimmick Mahaffey, Mr. Canoyer?
Yes.
Mr. Daggett?
Yes.
Mr. Chahowski?
Yes.
And Mr. Piattar.
Yes. All right, so F14, any questions what we are doing here?
So, Jason, I assume you have gone and done research because that's the kind of person you are. Do you have anything that you researched in the last month and a half that can be added to whether or not it is a material?
I have an opinion.
Okay, I want your opinion. You are
Okay.
a subject matter
All
expert
right.
here.
All right. If anybody cares, there is one case that I did find that's relevant.
Okay.
If you do want to read it.
I will look at it, yeah.
Okay. So I'll make my finding first. So the purpose of Mass General Law, Chapter 48, Section 16, which deals with reapplications, is to give finality to the administrative proceedings and to spare affected property owners from having to go repeatedly into the barricades on the same issue. Cited right out of Rainey versus Board of Appeals in Nantucket. Defiance of such finality by the applicant, the owner of 13 South Point Road, to this board's first decision that denied her special permit application to expand her pre-existing non-conforming structure is exactly what happened here when she submitted the same special permit application to expand this structure. For this reason, and as explained below, the applicant's resubmission must be denied. To hear a special permit application that was unfavorably and finally acted upon within 2 years of its final unfavorable action under General Law 48, Chapter 48, Section 16, a board must make findings that the reapplication is accompanied by circumstances that are specifically and materially different from the original application. The burden rests upon the applicant to demonstrate that such circumstances of the reapplication are specifically and materially different from the original application, with citations to that case. In the board's first decision on June 10th, the applicant's original special permit application was denied when the board found that the 10-foot front yard setback of the applicant's proposed structure would increase traffic by forcing more on-street parking onto what is an already narrow road with minimal room for the passage of vehicles, that the structure would create an undue concentration of population, that the structure would create a fire hazard or other danger, and that the structure would be detrimental to the established or future character of the neighborhood. All these reasons for denial were related to the 10-yard front yard setback of the proposed building. The applicant claims that her reapplication is materially different from her original application by the creation of additional parking spaces and the elimination of a deck from the rear yard of the proposed structure. I disagree. This application does not address the root cause for the reasons of the original denial, which is the intrusiveness of the proposed 10-foot front yard setback of the structure. These changes additionally are far from being materially different from the original application because the applicant used the same identical plot plan for each application. That is Exhibit 9 from the original and Exhibit 1 from the reapplication. One could not reasonably find that this reapplication is materially different from its original unless the front yard setback of the proposed structure was significantly increased on a new plot plan to address the board's original reasons for denial. The applicant's eliminated deck is illusory within both applications because it only appeared within a three-dimensional computer animated design and was not shown on either plot plan. The proposed additional parking spaces of the reapplication does not create a material difference because these spaces do not address the intrusiveness of the proposed structure on the front yard setback. So in conclusion, I find that the applicant did not meet her burden of proof and that the reapplication request must be denied. So that's just my finding. Everybody's free to make their own and vote how they so desire. But that is what I found. I do not believe, paraphrasing so many words, that laying out parking spaces and the elimination of a deck shown on a 3D CAD drawing that didn't appear on a plot plan creates a material difference. I think there has to be a change with the setback, which was the root cause of our original denial, so. Would anybody else care to make a finding of their own? All right. Is there a motion to find that the application is materially different from the previous denied special permit application?
I'll make that motion.
I'll second it.
Any discussion? So here, a yes vote would be that the parking spaces and deck elimination, or the addition of parking spaces and the elimination of a deck create a material difference. If you vote yes, then, and if 4 people vote yes, then we go into the special permit analysis. If there are more than 2 no's that they do not, then the analysis stops. Are there any questions?
No.
All right, Ms. Morgan, can you pull the board?
Nick Mahaffey,
No.
Mr. Canoyer,
No.
Mr. Daggett,
No.
Mr. Chahowski,
No.
and Mr. Piattar.
No.
So now you jump to the last page where you make a decision. And it's like the last one, it's phrased in the affirmative. So if you vote yes, you're going to go ahead and grant them the special permit. If you vote no, it's denied.
All right. Logically, it would be, because we're not here deciding the special permit, follow. So is there a motion to approve the special permit with conditions?
I'll make that motion.
I'll second it.
Any discussion? Hearing none, Ms. Morgan, can you pull the board?
Nick Mahaffey,
No.
Mr. Canoyer,
No.
here we go. Mr. Daggett,
No.
Mr. Chahowski,
No.
Mr. Piattar.
No.
Okay, denied.
Not least, is there a motion to direct Ms. Morgan to sign the decision on our behalf?
I'll make that motion.
I'll second it.
Any discussion? Hearing none, Ms. Morgan, can you pull the board?
Nick Mahaffey,
No. Oh, yes. Go ahead. I
Do you
got-
really want me to come in and sign the decision?
No, I don't need to
Mr.
take.
Canoyer,
Yes.
Mr. Daggett,
Yes.
Mr. Chahowski,
Yes.
and Mr. Piattar.
Yes. All right. Last item, is there any other business that we have?
The last business, it states here that the next meeting is to be determined, but in reality, your next meeting should have been on November 4th, but where there are elections happening, on the published schedule, it's Wednesday, the 5th. So your meeting, and you've got 2 cases on basically the same.
Okay,
same
Wednesday, the
topic.
5th, I'll be in Disney World.
You'll be
Or
in Disney World.
Good for
Disneyland,
you.
Disneyland.
All right, well, there's still time to re-notify the abutters and all that good stuff. So let's find a date, because you do have something that's scheduled to come before you. And if it's after the 14th, I'm not quite sure where you're going with staff, so.
So you said 6, or
Let's see, November,
you said the 4th is when the elections are, right?
yeah,
Are they stealing the 11th from us? The selectmen?
no, because it's Tuesday.
Oh, right.
Can we do the 11th?
You can do the 11th.
I can do the 11th.
That's
Oh, it is
Oh,
Veterans Day.
Oh, Veterans Day, yeah.
Right, That's a
No.
problem.
You should-
Yeah, I'm going the 5th, 6th, and 7th.
You want to,
What,
can we do Monday?
I can do Monday, yeah.
If we can we do the 10th? Is there space for that?
Let's
I
find
can do,
out
I
if
can do Monday the
selectmen-
3rd if.
Oh, I'm sorry, did somebody say the 3rd?
Either
I
one,
said the 3rd or the
3rd or the 10th.
3rd or the 10th.
Monday
Yeah,
the
3rd or the 10th's fine with me.
Yeah, there's not a high likelihood you're going to have the selectmen meeting. So November 3?
Yep, that's fine with me.
November 3, okay, we'll get the word out.
Thank you.
Now, when is your last day?
November 14th.
14th. All right.
We are
So you're-
we've had no one so far apply. So we are working internally to figure out what that transition is going to look like. At some point, Jason and I will have to meet, as will Dan Moran and I will have to meet to talk about what that means in terms of staff support and decisions and meeting minutes and all that good stuff.
Oh, boy.
I
So-
saw that Dudley's also looking for a town planner.
Yeah, they've been looking for a while, and they've been trying to split the planner position with another town, which unless you drink a lot of caffeine, I think that's a really difficult thing to do.
Yeah,
So-
I drove past this afternoon and went, oh, they're looking for one too. Well, that's
Yeah.
lovely.
Yeah, it's just so happens to be that there are a lot of people in my age cohort who are moving
Transitioning
into
out.
retirement. There are a lot of folks coming up, but there's not a lot of people right in the middle, which is the sweet spot where we got to find someone who has enough experience. There's a lot going on in Webster. So we want to make sure, we've worked hard to get you where you are today, and as is the planning board. And, you know, I want to make sure that legacy lives on.
Yep. Yeah, we don't want to go backwards where when you started, it was just the building commissioner and downstairs. And before then, it was like a dungeon down there where that office is.
It is still a dungeon down there.
It's not as bad as it used to be.
be
Not
honest.
nearly as bad as it used to be.
So, yeah, we don't want to go backwards. So I guess you're stuck with us for one more meeting.
Yes,
Yes.
yes. Well, the
More
good
meetings
news
in
is that you
November.
don't have anything else in the hopper beyond
Yeah.
that, so you might get a little respite.
And do we have anything that if the ZBA related that's going before the town meeting in October?
Nope,
No.
So we don't have the additional dwelling unit stuff?
we don't have any of that stuff. We've been waiting to see what the transition was going to look like. Things
Okay.
will be going forward. I'm going to start work on drafting ADU bylaw, trying to update our solar bylaw as it relates to battery storage, which is now a protected use under Dover. And what was the third one? There was another, we have stormwater regs to get done at the planning board. So I'm going to get all that rolling, and maybe I can get some of it completed.
Let us hope.
All right, is there a motion to adjourn to November 3rd?
I'll make that motion.
Second, all in favor, say aye.
Aye.
All right.
Okay,
Right.
microphone.